Okay. Anything else you want to put on the record before I call the jury in?
Yeah, we need to say, on the record before we get.
How lengthy?
Minutes.
Go ahead.
Keep-
Just so you know, you're putting this on the record. You're putting this on the record. I'm not listening. Showcase the record.
Your Honor, Judge Oakley, respectfully assert this court.
All rise. The report now in session. Honorable Judge Oakley presiding.
Come on, Mr. Cassell. You folks can have a seat. All right, appearances for the township. Have a seat. Make yourself comfortable. All right, so Mr. Crucell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to address the request of judicial bias and the process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Crucell?
It's covering all the judicial bias.
Okay, listen to my question. Is it any different than the last motion to stay proceedings you filed? Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
I just have the same straight on you didn't give a shit about what I had to say.
Okay, hold on. Listen, Mr. Crucell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers as cheating agreeing telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have stopped a while ago.
That's not the way it works. Mr. Crucell, hold on. Okay, that's the last time you're going to interrupt me today without a contempt of court charge. Is that clear?
Your Honor.
Is that clear?
She gets me this entire time. No one has made her answer.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept? I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
So if you're agreeing to that, that means you guys are lying against us.
So that means in any case, when I buy the arguments from one side, that means I'm colluding against the other.
You're agreeing.
Yes or no, Mr. Crucell? No, you have to answer my question. Contempt number one, $100. Answer my question. Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? $200. Yes or no? Because I can do this all damn day. And when I get tired of this game, then I tell them to put you in custody because it's contempt of court, criminal contempt in my view.
Yes.
It is. All right. So now, any argument you make from there, I'm going to deny because that's an unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making...
What statement is that? I thought we were talking about Judge Green's SOS statement.
When you made this statement that you were setting aside my regular trial, saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting it all aside, not allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my way and setting it aside and what you were doing.
Mr. Crucell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself.
The video begins with the judge expressing clear frustration over the delays and procedural issues in the case. He questions why the parties are spending so much time going back and forth, emphasizing that he has other cases to handle. The judge sets the tone by stating he will proceed with his original plan, indicating his impatience with the ongoing arguments. The case, J Group Holdings versus Stanfield, is called, and the defendant greets the court. The judge immediately points out that the defendant's interpretation of the case is unclear, highlighting the confusion surrounding the pleadings and documents. This sets the stage for a contentious hearing, with the judge already appearing skeptical of the defendant's actions.
Third contempt. Do not interrupt me. When I said your objections don't mean shit to me is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence. And you say, I object, Judge. She hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. That's a proper legal objection. When I rule in her favor and you say I object and I say, what's your objection? And you just disagree with me, that's not a legal objection. That's why I said your objections mean shit to me, because you're not using the word appropriately, because you don't know what you're doing. That's what I tried to tell you originally the first time you were here. You've never been to law school. You've never tried a case. You don't know the rules of evidence and all the other things that have to be in play to have a trial go forward appropriately, properly, and to be perfectly honest, in your best interest.
You're trying to spin the stereotypes.
I'm not spinning.
Based on you, you're not allowing me to do it. And that's what you told me.
Okay. All right. So let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
Especially with the jurisdiction, she never wants to it's on the why is it on the prosecutor to prove those things? There's all sorts of irregularities.
All right, let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking question on shows the extent everything that there is enough to show you're supposed you need to proceed.
Once again, you're not answering the question I asked. You just said you will not participate, and I asked, what do you mean by that? I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
Go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the point of me getting all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
Like put on record that is whatever you would like to do from there, you can, because I don't until these things. Like I say,
Hold on. Is this statement preceding all these motions you filed? Okay, then let me make my ruling on all of them. I think there's a motion to dismiss for lack of jurisdiction, correct? Okay. Would you like to respond to that one? Because I think that's already been addressed.
Please arrested Mr. Purcell while he was in Huron Township, but Bigwood District Court has jurisdiction over offenses that occur within the township, both civil and criminal needs.
Did you appeal Judge Green's decision on that motion?
I'm investigating because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct? I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again, don't interrupt me because I can go to 4 real quick. Judge Green, a judge in this court, ruled on that exact motion and denied your motion. That motion has not yet been appealed, and it certainly doesn't get appealed to me. Is that clear?
Yes.
Thank you. Next motion. Motion to...
The judge can't just come in here and say that there's...
Yes, the judge can. Listen to me. Then appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion.
The judge reiterates that he had previously struck the defendant's pleadings due to improper caption changes and instructed her to refile and serve them correctly. He questions whether the defendant followed his orders, to which she responds affirmatively. However, The judge expresses doubt, noting that he doesn't see the new filings as court file, and the plaintiff's counsel claims he hasn't received them either. This discrepancy raises questions about whether the defendant complied with the court's instructions. The tension builds as the judge presses the defendant for clarity, highlighting the procedural missteps that are delaying the case.
It's issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay.
All the reasons I've stated, there's
Okay. Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. I really would. Because here's my dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant because that's my job as the gatekeeper after the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge, not because I don't like Mr. Crucell. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision? Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling. That's not a legal objection. So that's two motions down. The next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside your defaults. All right. Do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside, defaults that were set aside are reinstated. Is that really what you want today?
Well, listen, Mr.
Purcell, yes or no? You filed a motion asking me to set aside a decision that was made. Do you really want me to set that decision aside? Because that means those civil infractions are then in default and they're done. Is that a yes or no? Yes or no? Do you want me to set aside those do you want me to set aside the default set-asides? Do you want me to reinstate those default judgments? Then I'll deny that motion. All right. You filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution? So am I. All right. The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
Essentially, yeah.
Okay. Okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of non-consent. Motion for judicial notice. What does that judicial notice of what?
Certain terms that this prosecutor keeps trying to abuse and apply in this case.
Confusion arises over a dismissal filing that the defendant claims she did not sign. The judge points out that the defendant, as a counterplaintiff, cannot dismiss the plaintiff's claims, only her own counterclaims. He refuses to accept the dismissal filing, emphasizing that the defendant must get the caption and procedures right. The defendant attempts to explain her actions, but the judge cuts her off, clearly frustrated by the repeated procedural errors. This exchange underscores the defendant's lack of legal expertise and the judge's growing impatience with the delays caused by improper filings.
Is that what you're concerned about? Is you're not going to be able to make the argument?
Yes.
Get what stuff on the record?
Filings.
Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions.
All of this has to go. All of everything's taking place.
No.
Exactly.
No, that's not the way it works, Mr. Cazell.
It is.
No, Mr. Cazell. All right, listen, brother, listen. You don't get to tell me what my job is. I've been doing it for 25 years. Listen. Well, then that's why they have appellate courts for the fourth or fifth time. I decide what this jury gets to see today. I decide. That is, by definition, the role of the judge at a jury trial. I get to decide what goes in front of that jury. If you don't like the decisions I make, you appeal those decisions. That's the way it works. What this jury has to decide today is whether or not you violated the township ordinance on that date. Hold on. None of these legal arguments about whether or not I should recuse myself or whether or not you notice me up for constitutional rights, none of that has to go to that jury. And none of it's going to.
That's why they should have tried and not emergency stop, motion stop.
I already ruled on that.
Certainly back acknowledge my motions for my next battle.
Once again, I'm not trying to, I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. And you can disagree with me that all day long. But we're going to do it, once again, we're going to do it my way. You can appeal me. I've been appealed before. I'll probably be appealed before I retire again. It's okay. That's the way the process is set up. I encourage you to appeal me. All right. I am open-minded enough to think that perhaps my mindset about your whole travel, whole thing, maybe that's all wrong. So a circuit court judge can tell me I'm wrong. But so far, and I've ruled this way a number of times on the traveling issue, nobody's ever appealed me to lead to a circuit court judge to tell me I'm wrong. But I'm open to that idea.
I said, well, you just keep. Each judge has done the same thing. They just keep setting it aside. And acting like it doesn't even exist, not allowing me to make my case. Just violating my rights to be able to produce my case in my head.
What's your case that traveling doesn't mean operating?
I'm sad to the fact that this court's violated my due process rights in every way, the judicial bias. And
All right, then appeal me. But today we're having a jury trial.
an unlawful jury trial. And I think that waiting statement in the record.
But hold on a minute. Once again, I want to know what that means. You're not participating.
Not participate in a jury in a trial where there is severe bias in this court against it. It violates my rights to a fair trial. 100%. And you want to keep overlooking. No, I know they make you seem like they're not a big deal. And
No, your rights are a really big deal.
obviously not. Because if you can sit there and say that the things that are happening, the things you're saying, and just try to give this excuse to all, just because I agree on this, you are aligning yourself with the prosecutor on my right to trial. Completely setting aside, not allowing me
Mr. Purcell, no, I'm not. Listen to me. No, it's not. Listen to me. Listen to me. She could step out of the room, and I still think your travel argument is bullshit. Traveling. The right to travel was when you did it by Shank's mare. Then appeal me. That's my decision. Appeal me. When you're driving a motorized vehicle or traveling in a motorized vehicle, that brings all those ordinances into play. That's my legal ruling. Appeal it. I encourage you to do that. But that whole traveling argument, which, dude, I've been through that argument a whole lot more than you have. Trust me, in the last 25 years, I've had that argument a lot. Traveling as you try to apply it meant you could not be stopped by the government from walking from one venue to another. But when we got motorized, then the rules kicked in.
rulings from the American jurisprudence side that literally stated that yes, first of all, y'all have and including automobiles, as long as one does not interfere with another's rights. And this is something that is not just to be secure.
Then appeal me. Take that precedent and appeal me.
As well.
Okay, that's your right. I'm not trying to stop you from doing any of that stuff. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate today.
The defendant shares personal circumstances, explaining that her grandmother has passed away and she needs to travel for the funeral. She requests a hearing after April 1st, but the judge denies the request, stating that the case has already been delayed too long. He reiterates that the defendant must either correct her filings or hire an attorney to represent her. The judge's refusal to grant leniency, despite the defendant's personal situation, highlights his focus on moving the case forward. This moment adds emotional weight to the hearing, as the defendant struggles to balance her personal life with the legal proceedings.
How is that unbiased and impartial? You've decided to engage yourself in this venue, in this arena. That means you got to know the jury structure. Yes, you have.
I'm forced to be here.
But you didn't have to do it. You didn't have to do it as an untrained layperson. You had free access to qualified, competent legal counsel. They're still here. There's one right there behind you. He's still ready to help you. You chose to do this yourself. That means you've got to know the court rules. You've got to know the statutes and the ordinances. You've got to know the rules of evidence. And if I help you through those lapses in your knowledge base, that's not fair to the prosecutor. Then I'm taking sides. And now I'm not going to let her walk all over you and try to trick you because you don't know some of those rules and statutes. But I am absolutely going to require you to know what you're doing because you've chosen to do it. That doesn't show bias. That shows impartiality.
There's no partial anything. I have the.
Once again, Mr. Crusoe, that's your opinion. No, it's your interpretation of the facts. So you have to appeal my decisions. And look, dude, the fact that you're not in a jail cell right now shows how impartial I am.
When Officer Rice literally pulled up to me my wedding days before any of this even happened and talked to us about the traveling. Even told me I was well within my rights. Gave me every clarification that I was well within my lawful rights. This was all a retaliatory thing from the beginning. And then even when the chief called me. He even called me trying to I said, well, it's not over me. And then he goes to some more people. And then he tries to get me to not pursue legal matters. And then he's mad at me. And then the day that I file for my body cam, I'm getting removed from here on a Little League.
And stop. Hold on. I don't doubt that it is. But I think we got into this a little bit the first time you were here. And I told you, that's not proper for this venue. If you want to complain about the way the Huron Township Police Department handled this, you can file a civil lawsuit against them if you want to. But what's in front of me is one civil infraction and 2 misdemeanors. That's what's in front of me.
Oh, every time I force it to make my case, the court just keeps setting all my stuff and not allowing me to do it.
Because I'm going to make decisions based on the facts. That jury hopefully is going to make decisions based on the facts that are presented.
How would it be facts in this court continues to not allow me to get my facts?
Because the facts you want to get into, what facts do you want to get into? The chief had some conversation with you?
It's not even just that. I mean, well, yeah, regardless, I have all of that to cover too. The fact that my offense, based off what I was doing, I didn't have to produce any of that. It just keeps all just thrown aside. Every single and just not even trying to acknowledge any of it.
So hold on. I don't understand. Hold on. You want to be able to testify to this jury?
It's not. I'm just finding. That's what I'm saying. It's the amount of traditional bias in this case.
I'm done hearing about bias. You need to appeal me. I don't feel I have bias.
Well, I don't feel that I would have a fair trial here with everything that's going to take this file policy. Why did we?
And I've denied all these things.
Well, of course you can deny it. Again, showing again. Then this.
Once again, Mr. Crusoe, just because I disagree with you doesn't mean I'm biased against you. Maybe I just think you're wrong. Is it possible we could have a difference of opinion?
Great told me that she was just bad and housing myself against the Secretary of State and make sure to do this isn't a big deal. I'm showing.
I'm not going to.
It's so impartial. Support here.
I've never brought a Secretary of State, have I?
In fact, this is where this all stems from. These are the things I've been trying to get noticed. This thing talked about.
What do you want getting noticed that we're not getting noticed? It is not collusion. What? All right, listen. What are you going to do today? Because I'm ready to bring the jury, and I've denied all. Stop. I've denied all your motions. I'm ready to set the trial. Are you not going to be here?
Nothing you can see in 48 years, right? And it's especially regarding the jurisdiction stuff. Well,
Once again, we're at $300 now. We're going to 4. I'm going to ask you the question again. I'm ready to call the jury. Are you going to leave?
I don't know. There's no way they're going to hear a trial here.
That didn't answer my question. I need to know how I'm going to proceed because we can have the trial if you just sit there. I'll just tell the jury you've decided to represent yourself and you might not say anything today. So that's the way you want to go with the trial.
The whole case against that.
Okay.
Everything is on the back and
Okay. Okay. No, let's on the record as you feel they should be.
Thank you, Your Honor.
Thank you, Mr. Bowditch. I appreciate the efforts. All right. Caitlin, enjoy your Monday.
Yeah, thanks. Yeah, I got the card here. Joe, I got all this.
Just have it on the computer.